All right, everyone, let's go ahead and get started for today. So thank you all for joining. We have a fun webinar today. It's one of my favorite topics. I do love to talk about federal and state confidentiality. And maybe it's just me, but hopefully we'll make this topic a little bit more exciting for y'all. And so far in my neighborhood, it's been kind of a busy, kind of loud morning. So hopefully we won't have too many interruptions or any sound issues. But if we do, then we will have this recording sent out tomorrow so you can rewatch it and we can work through that. All right, so of course we are supported and funded by the Office of Violence Against Women. So that office definitely allows us to do the work that we do and the work that I love to do. Let's be real. All right, so, you know, most of you who do know me know that I am an introvert, but I, like most of you, have been, in my house alone for quite some time. So let's connect, let's interact during this webinar, okay? So this is what your go-to webinar control panel is going to look like, okay? So if it doesn't look like this, then go ahead and click that little orange arrow at the top, and that is going to expand and retract your control panel. So, play around with that, make sure that it expands and it, retracts. There is a couple features that we can utilize, and we will utilize this webinar. So the first one is that raise your hand button there. So with this, usually when I ask a question like, hey, how many of y'all love Ogden? And then all of you raise your hand, all of you click that to raise your hand, right? And then I can kind of get a consensus now, okay, so, most people or whatever. And then down here at the bottom, this is what we're going to use the most. So this is the question box. So I will ask you questions. We'll have questions pop up, stuff like that, and then you will be able to answer them in this question box. And so why don't we try it right now? So everyone in that question box, type who you are, where are you from? Are you an advocate? Are you law enforcement? Are you an avid fan and lover of all things that are state and federal statutes, and you just want to talk about that today? Let's see. Okay. Oh, we have some therapists here. Definitely love when we see some therapists and social workers. Ooh, some CJC folks. That is my cat Torico. He's going to say hi to us. Let's see. Ooh, we have a couple volunteers from the local domestic violence service providers. Oh, we got folks. We got some folks from Alabama. Love when our Alabama folks come. A couple more therapists. Ooh, we have some ER therapists. That's very, very cool. Victim advocates. We have some caseworkers. Dang, it looks like we have folks from all over the state and a couple folks from out of the state. Nice. Awesome. Thanks, everyone. Okay, so if you will notice also on your, I saw a couple of folks calling out from Ogden. What's that, right? So below the question box, there's going to be a handout little box. So you can actually download a PDF of this presentation right now. And if you're having issues with that or you can't find it, stuff like that, then I will also be sending this out in an email a little bit later. All right, so let's talk about the real reason why you're here, right? I am a great resource of free CEUs, right? So yes, there is 1 hour of CEUs available for this presentation, and you will get a link to this quiz tomorrow. So tomorrow, I think at noon or 1, Mountain Time, you will get a email that has a link to the quiz, and you can fill that out. You have to get 70% or higher, and then I'll send you a certificate. And remember that some of the questions are, you can select multiple of them, so just be aware of that. So make sure that you get all the questions. Okay, friends, let's get into it. So federal and state confidentiality provisions and best practices. Okay, so here's a couple of our objectives for today. So we're going to really dive into understanding the difference between confidentiality and privilege, right? So we are going to explore VAWA's confidentiality provisions and really delve into these releases of information, right? And what they are and why they are required. So we will talk about mandatory reporting within states and what that looks like for VAWA, and also big question in the room. Usually the elephant in the room is, how do we respond to a subpoena, and what the heck even is a subpoena? All right, so first off, I'm going to tell you a little bit about the Utah Domestic Violence Coalition. So we are a nonprofit, so we are the state's domestic violence coalition for the state of Utah. And so what that means is we are a supportive organization. So we support all of the folks in Utah that are serving and working with survivors of domestic and sexual violence. So we do this through a number of different ways. I'm sure most of you know already, with education, training, webinars, stuff like that. And also, site visits, technical assistance. And when I talk about technical assistance on a coalition level, what I am talking about is, folks calling in asking about what are the best practices for working with survivors, not how to connect your, your mouse to your laptop. So, I probably could help you with that, but mostly I do stuff with best practices of working with survivors. So, yeah. Okay. So here is the slide about me. And it definitely is a fun slide, a slide that I enjoy. So, all right, my name is Andy Tremonti, and I use they, them, their pronouns. I'm the Education and Outreach Coordinator for the Coalition, so that means I am over the majority of the education that the Coalition offers. And the outreach part, I specialize in underserved survivors, and more specifically, Two-Spirit and LGBTQIA survivors. So that's the bulk of the work that I do as well, especially with my technical assistants. My education history is in psychology and women and gender studies, and that fits pretty well with what we're talking about, right? All right, and I'm also a criminal justice grad student. I'm pretty excited about that. So yeah, we'll see where that goes. In my experience, about 9 years of working with specifically Two-Spirit and LGBTQIA folks and other underserved survivors of trauma. So yeah, I have a lot of really unique experience. And last but definitely not least, I am a Sasquatch enthusiast. So those who do know me, I'm pretty sure you're aware of this. You've heard some of the stories as well, and yeah. So this week, this is what I'm working on. It's actually one of the miniatures for the Power Rangers Heroes of the Grid board game, and this is Poluticorn. And so I've been working on his feathers in the back, and so hundreds of little tiny brush strokes to kind of get that feathering effect. So here's Sweet Todico, the one that you will probably hear the most meowing in the background, and then here's Sweet Jorge. And of course, my favorite, one of my biggest self-cares, what's keeping me sane right there, is Xena. So, all right. So confidentiality, let's get into it. Okay. So one of the big important things when we talk about confidentiality is, why is it important, right? So we know that it's a part of our grants. We know that, it's something that we hear about every time we fill out grants, when we're on calls with, federal, grant administrators. But what does it actually mean, right? And why is it important? So some big things here on the screen that you can see is, confidentiality is important on many different levels. Mostly is that we're eliminating barriers for survivors. We are making it easier for survivors to access our services, to feel less shame, less humiliation, less blame, and even hopefully eliminate a lot of that rejection, right? And give them, their power back, that they do have control over their information and over their story, and that only them and only they can really decide who and where that's shared, right? And especially with confidentiality, when survivors are, guaranteed that there's confidentiality or know that confidentiality is a thing, they are more likely to disclose that true nature of the abuse, that true nature of the assault, right? And that can be really beneficial, especially when we're providing resources for folks, right? So other reasons, we're of course enhancing that survivor's safety, because that survivor, may feel more likely to share their story, may feel more likely to, talk about what is actually happening in their life. And, when folks do disclose violence, especially if it's to a non-confidential source or someone who may not, know how to respond, that unfortunately could potentially increase violence, or potentially increase, some of their danger, right? And of course, we definitely want to preserve the dignity of survivors and empower those survivors. So that's a really big part of this confidentiality, because they get to decide what happens to their information. They get to decide, right? So think about when survivors do lose control of their own information, is, especially when we talk about court cases, is that folks can lose, when they potentially lose, power over their own information, is that this could absolutely be used against them in a court of law, right? So in custody, in divorce cases, even, child welfare cases, right? And we're going to talk a little bit more about that later, especially when we're talking about releases of information, and what happens if when third party folks have access to survivors' information, and what some of the potential dangers and even benefits that can have. So of course, this can, a survivor losing control of their own information can have lasting effects on every aspect of their life, right? Not only people who they know finding out about the abuse, but also even in their employment, right? And think about the situation, or the current situation that we're in. So we're in the middle, of a global pandemic, COVID-19, and Utah hasn't even seen the worst of it yet, and it's already affecting our survivors so significantly. It's already affecting our domestic violence service providers and our our social service organizations so severely. And think about how, when a survivor cannot control their own information, that could greatly increase that exposure and potential danger and rejection. All right, so we're going to define a lot of different terms today. I would love if you remembered everything in this presentation, but that is why I also, give you a handout of the presentation, so you can remember and you can revert back to it, okay? So the first thing that, I want to define is a confidential communication, right? So in many of our jobs, when we're having meetings with employers, employees, stuff like that, there's confidential communication, right? It's a communication that we, basically expect there to be an element of privacy, that the general public, other folks are not getting access to this conversation, this information, and really importantly, that there's no legal requirement that the recipient keep that information private. So we're all kind of agreeing like, heck, yes, we would love for this information to be private and not to be shared amongst other people. However, there's not necessarily a legal piece behind that. So we have our first cat break. I know talking about legal terms, kind of delving into this can be difficult. So here's a picture of my cat sleeping and a plane is going by, so we're gonna mute. All right. So I've had a couple folks say that they may have trouble hearing me. I did just mute the audio because there was multiple planes that were going across the sky. If folks do have issues with audio, there is a little audio sound check or troubleshooting button in your audio tab on your control panel. So definitely click through that. It may be something as easy as just needing to select which speakers. So even for my computer, I have 5 different options for speakers, right? I only have one set of speakers that are connected to my monitor. However, Windows offers multiple different choices. So just go through that if you're having issues hearing. Cool. All right, so now let's talk about privilege. And we're going to talk about statutory privilege. We're going to talk about that legal definition of privilege. So we're going to build upon these definitions. So statutory privilege, so this is a confidential communication, right? So remember that those basics of that, right? So this is a little bit different because it's created by statute. So this is a law, right? And disclosure is prohibited without permission. So this is, where the law says, hey, your position, your job, your licensure says, hey, you cannot share this information without consent, without permission, right? And of course, that's going to usually be written consent, okay? So, this can be really beneficial, especially during court cases and other, proceedings. We're going to talk a little bit about some of the relationships here in just a second. But especially with domestic violence, that, think about how someone experiencing domestic violence, how that could be used against them in many different court proceedings, and how that could really hurt them and really not only re-traumatize them, but also increase their danger. Right? Okay. So we're going to talk a little bit about this. So here's a couple examples. So, folks who are married, right? I'm sure all of you have seen an episode of Law and Order, right? And, almost every episode, there's a married partner who, cannot be compelled to, testify against their partner, right? And of course, attorney-client, privilege, right? That a client, things that a client says to their attorney cannot be divulged. And even think about when you call or receive calls from jail or prison, that one of the part of the recording is calls are recorded unless it's a privileged call between attorney and client. And of course we have religious leaders, so think about confessional, folks talking to their bishop about certain things, right? And then therapist and patient. I definitely love that my therapist doesn't go around talking about all my sweet, my hot goss in my life to people around, especially, the stuff that we talk to our therapists about can be really, really personal, right? And of course, doctor patient, right? So there is something that's missing here, right? So let's talk a little bit about advocate privilege, okay? So this is generally a term that's used to describe the statutory privilege, right? That advocates, domestic and sexual violence advocates, let's see, hold on. All right, I'm sorry. I think there was a little bit of construction going on outside. There's a little bit of a beeping. So, okay, we're back. So, this is communications between sexual assault, domestic violence advocates, and the victims and survivors that they're working with, right? So yes, like many things in Utah, it's a little bit complicated. So we have a couple different statutes, and I'm going to talk to you about what they cover and what they don't cover, right? So this first statute is the Confidential Communications for Sexual Assault Act, okay? So how this statute defines statutory confidentiality for sexual assault advocates or counselors is this person has to have received a minimum of 40 hours of training specifically in counseling and assisting victims of sexual assault, right? So that's how someone who works at a rape crisis center, a sexual assault center, how they have statutory privilege, right? And then we have the Confidential Communications for Institutional Advocacy Services Act, right? And so this applies more to universities, colleges, stuff like that, right? Where this one is a little bit different. So this one defines folks as certified advocates, right? And not only do they have to work at a qualified institution that provides victim services, right? But also they have to complete a 40-hour, core advocacy training as well. But this one is not specific to sexual assault and sexual violence. So this one includes, folks who are experiencing sexual harassment, sexual assault, rape, dating violence, domestic violence, and/or stalking, right? So there are, several 40-hour trainings that are out there. There are three big ones. There's the UCASA training, the 40-hour sexual assault training, the UDVC, 40-hour domestic violence core advocacy training, and then we have the UOVC, the Utah Office of Victims of Crime, 40-hour training as well. And there are many service providers that do offer their own 40-hour training throughout the state as well. An example would be like Rape Recovery Center has an excellent sexual assault 40-hour core advocacy training. All right, and it's really important, and we're going to talk about this multiple times throughout this webinar, but remember that it's the survivor's choice to share or not share their information, right? And we need to make sure that we're getting informed consent. And we are going to go over what informed consent means. And it doesn't mean slapping a consent form in front of a survivor and saying, hey, yo, will you totally sign this? Trust me, I just need to share your information with da-da-da. Absolutely not. And we're having conversations of the benefits of signing a release of information and also possible negative outcomes. So here's another cap break before we get into some more legal stuff here. This is Todiko. I'm not sitting on anything that he sits on because he's enormous. So, all right. So now we have VAWA, the Violence Against Women Act, FVPSA, the Family Violence Prevention Services Act, and VOCA, Victims of Crime Act, right? So the big one that we're going to talk about is VAWA. And all three have very, very similar confidentiality rules. They've all kind of adopted these confidentiality rules, from FVPSA and VAWA. So It's really good to kind of have this basic information on confidentiality, especially with VAWA, because it is a very, very strict, which is good in many ways, and we're going to talk about that. So VAWA, Violence Against Women Act, is survivor focused. So we're focusing on that survivor. We're putting that survivor safety and healing #1, right? So confidentiality is a grant condition. So you do have to be confidential. You do have to uphold confidentiality standards for the grant to, have the grant, right? And there's a big reason for that, okay? And so, yeah, we are literally required to protect, confidentiality and privacy of folks who are receiving services or folks who are even inquiring about services or folks who have been maybe declined services because we don't have the space or whatnot, right? Okay, so let's talk a little bit about non-disclosure. And maybe y'all have heard, folks say, oh, non-disclosure provisions in VAWA, non-disclosure provisions in FVPSA, non-disclosure provisions in, and you're like, heck, what does that even mean, right? So basically, anyone who receives even $1, even a penny of VAWA, funding, FVPSA funding, you cannot disclose or reveal any personally identifying information or individual information, right? And that, like I said previous, could be in connection with services literally requested, utilized, or denied, right? So if you are full and someone comes in and, you're like, oh, heck, friggin', Karen came back to try and get services, you're saying that on your Facebook. Oh, absolutely not, right? Definitely not okay. What I would love for all of you to do right now is in that question box, I would love for you to tell me what personally identifying information is. You tell me, right? Because we're going to define that, because that's a huge thing to define. What is personally identifying information, right? Because it means something different for each place, right? Okay, so names, phone numbers, social security numbers, absolutely. Date of birth, absolutely. Address, gender, yep. Safety plan, oh yeah, yep. Relationships, diagnoses, thank you. Let's see, so any information, any data that could potentially be used to identify that a particular person, right? Yep. Let's see, story of abuse, right? What about sexual orientation? Is that personally identifying information? What do you think? Yeah, yep. Absolutely. What about gender identity? What about race, right? What about documentation status, right? So really think about this, especially, so this is really interesting because, I've worked with organizations before, obviously I've been doing this for a while. And, even when people share information, even one information, say like sexual orientation or gender identity, as soon as they say that, and especially in the area, I know exactly who they're talking about, right? And so think about, especially if me, someone who doesn't even live in that area, knows exactly who they're talking about, that other folks could potentially know exactly who they're talking about, right? Okay, someone had a question. So race, gender, documentation status are considered personally identifying information if identified with the person's name, but not by itself without a name attached. They absolutely can be considered personally identifying information. So think about, especially, okay, so in Utah, say you have a Black or African American survivor that goes into shelter, right? What if it is the only, that person, that survivor, they are the only Black or African American survivor in that shelter, or, they're someone that is known within that community because, for whatever reason, right? So absolutely, just even divulging their race could identify them, absolutely, and especially in rural communities in Utah, stuff like that, right? Absolutely, right? And even if someone identifies a certain way or uses terms that may not be used by majority of folks, or maybe even culturally based or a part of a specific community, that just using that way to describe their identity could potentially out them, right? Yep. Yeah, thank you. Medical conditions, occupations, excellent, everyone. You're doing excellent. Okay, so there are times when disclosure is allowed, okay? So there are three times when disclosure is allowed. So with informed, written, reasonably time-limited consent. So that is the release of information that we're going to talk about here in a second, okay? And then statutory mandate, right? So that an example of that would be mandatory reporting, okay? And then court mandate, right? So things like subpoenas, if there's a court order that says you have to, do this, supply this, so on and so forth, okay? So let's delve into releases of information. So there's definitely a lot of questions that I get on release of information. And we're going to go into all of that because there's a lot to releases of information, right? So again, here's some, more information about that disclosure, right? So folks, grantees cannot disclose, reveal, or release any personally identifying information without, individual client information, which could be also personally identifying information without the informed written consent of that person, right? So that doesn't mean that you grab a sheet of paper and be like, heck, hey, will you just like sign this and say that I can, talk to Andy at UDVC and give them, your information, right? So that absolutely cannot happen. There are standards, and I'll give you an example here in just a second. So there are some exceptions on releases of information, especially around consent. So if the person with abusive behavior, the abuser of the minor, the adult, incapacitated person, if they're coming in and they're saying, hey, I want to sign a release of information so that I can get information on my child because they're my child and I'm their parent or guardian. Absolutely not. If you are the person who the survivor and the child is trying to find shelter from, then you cannot be the person that gives consent to release their information. And that makes a lot of sense, right? So especially for folks who work, within, advocacy, we're like, oh, heck yeah, thank you. Yes, we definitely need that, right? Okay, so let's go over a little bit of what it means to be reasonably time limited, okay? So this can look different in each scenario, in each organization, right? Basically, we have to give a time frame of when this information can be shared, okay? It can't be open-ended. It has to have a certain number of days, a date that the information starts to be shared and when it stops, being shared, right? So some places have like a 15 to 30 day kind of standard. How about, can everyone type in the question in the box? How long is your release of information? How long is your time standard? Is it normally for 90 days or? Okay, so 15 to 30, 30, 15 to 30, 30, 2 weeks to a month. Okay. Ooh, someone says 1 year. Okay. I'd be really interested to hear where the person works that's said 1 year. I'm assuming maybe government. Yeah. Okay. Interesting. So, ooh, someone said 30 days post services. Interesting. Nice. Thank you all for typing that in. And someone did say depends on what the client wants, which is absolutely the point that we're going to get to next. So this bottom dot point, balancing inconvenience of signing new release with protecting that survivor, right? So think about, okay, so we know that we need to get in contact with maybe a caseworker at another organization, and survivor is in shelter. They got to shelter a couple days ago. We're kind of working through it. Things are going quickly. That we may only need to have this dated for 5 to 10 days, right? That we don't need to have it dated for our standard of 90 days. It just may not be needed, right? Or if we're working with maybe like a lawyer or an attorney for the survivor for a court case or, a divorce or protective order that we may, the survivor, it may be beneficial for the survivor, or they may want it to be a little bit longer, right? Because that process will take longer. So verbal releases. So especially right now during COVID-19 pandemic, we're starting to see more of these. And I'm here to tell you what is and isn't allowed on the grants, right? So I'm here to give you that technical assistance, that some of those resources, right? And this one is probably a hard one because we're probably doing it within shelter. We're probably doing it within our organizations, especially right now, because we cannot have contact with people, right? And we do know that we're getting an increase in domestic violence calls, this escalation happening. And also we're starting to see, it's really, really interesting. We're seeing some organizations have this huge influx of calls and, survivors trying to contact and get services. And then we also, on the other side, have people organizations whose hotline calls and, advocacy has gone down significantly because people are not safe, because people now are being are with the person who may be being maybe abusing them 24/7, that they can't leave their house, they can't go and talk to other people, that they can't, sneak away and have a phone call because, they can't leave the house. So very, very interesting. We're seeing both happen right now, right? And both are very dangerous. And so we are seeing an increase in verbal releases, right? So these are risky and they're not recommended, right? It's not best practice because we don't have that written consent. We don't have, even this like legal paper saying, hey, this person has been notified. We have decided that this is how long we're going to share their information, and we are also adhering to confidentiality standards, right? However, because of what's happening, we are seeing more of this. And, if this does happen, to make sure that we're having those conversations and getting written consent as soon as we can. Some folks have been, verifying identity of the caller on the phone by using a PIN number or a code word, something like that. So again, this is a really hard time. And your job is to, best meet the needs of the survivor while doing everything that you can to ensure confidentiality, okay? So what does, informed consent, right, actually mean? So I don't know how many of you have, in college, maybe high school, maybe participated in a study, and the first sheet is the informed consent sheet, and it says, this is what the study is, these are possible benefits, to you, these are possible negative outcomes, here's support if you need to connect with someone. Oftentimes they'll list therapists, like at schools, connect to the psychological resources, center, student wellness center, stuff like that, right? But basically it tells you, here are benefits and here are, risks to participating in the study, right? So when we're doing a release of information, it's really important that a survivor understands the alternatives to releasing their information, and also the risks and benefit of releasing their information, right? So, for example, benefits of disclosing, say, to a caseworker at another organization is that, advocate that you're working with at your domestic violence service provider can share information and help set up housing for you at the new location, be able to pass along information about you to help get forms and registration and things like this set up. It could also help with, going through the legal process, protective orders, stuff like that. But also the risks could be, the biggest one is that once a survivor's information gets to a third party, that it does not, now it does not fall under your organization's confidentiality policies and practices. So if I am working with a landlord, that once that information is shared with that landlord is under no legal requirement to adhere to VAWA confidentiality. So that information can get out, that information, may be shared with other people within the office, you know, people that may know the survivor, the victim's partner, ex-partner. So very important to understand that. And it's really important to have those conversations. The more information you know, the more you're informed, the better you can consent, and the better you know, the decisions you can make because you have that information, right? So we kind of talked a little bit about this a second ago, but what I guess a really good way that I like to put this, especially with informed consent is a conversation that you're having with a survivor, that you're having with a victim, that literally ends with a signature, right? So, you know, having conversations about what it means to sign this, what it means to share your information, you know, who has the information, what we're going to do with it, stuff like that, is really, really important before survivors make any disclosures and make any decisions, right? And it's, you know, really important to talk about that they at any time can rescind their consent to release information, and that should be in part of or included during that conversation, excuse me. So here is some basics of what should be included in a release of information form, okay? So absolutely a description of the information to be released. So don't, you know, it's not best practice, avoid, do not do, you know, don't put survivor's case file. Absolutely not. What does a case file mean? Does it mean everything that they have signed? Does it mean every interaction that they've had? Does it mean notes from their therapist, from their case manager, from their advocate? Does it mean information, notes, and forms from transitional housing, from other organizations and resources, right? So absolutely, nope, nope, nope. Don't ever put case file, right? Because that is vague. It could literally mean everything and anything. So don't do that. An example would be housing records or employment information, right? So say if they've been living in transitional housing, on-site transitional housing, and they're transitioning out to another place, and a housing advocate is assisting with that, that's signing a release of information for housing history within organization, that could be really beneficial, right? But make sure that we're naming the agency and even the person who we're sending that information to. So if you, there's been a number of releases of information that domestic violence service providers, even some of you on this call, have signed to have me come in and do advocacy and share information and help with certain things. And you have specifically written on that release of information that it's Utah Domestic Violence Coalition, specifically Andy Tremonti, right? And make sure you know the purpose, the duration, and the date. So I had a couple questions, so I'm gonna pop these up really quick. Okay, someone said many of our clients put class attendance since they need letters of attendance for DCFS or the courts. Oh, really interesting. So that would be like the purpose of the release of information is class attendance, and then maybe that service provider shares that they have completed a certain amount of classes or groups or something. Okay, so someone said, how long should you hold on to expired IO or ROIs, if at all? Okay, so depends on your grant. Super great question. So depends on your grant. So some grants you can be, some grants, your documentation standards can be 7 years, some can be more. So it really depends on your funding stream. So many, like VAWA and stuff, it's like 7 years. So be aware of your requirements, your documentation requirements, and your potential audit, your how long they can audit you for a certain year after receiving that funding. So you want to hold on to things documentation and stuff, if it's a part of audits, if it's a part of your grantee information and stuff like that, right? So I would follow up, especially with which funding source that you get. It could be different, right? And also talk to your legal counsel, because if there was a breach of confidentiality, think about statutes of limitations that if there is no proof that they signed a release of information, think of some of the legal ramifications. So find out through your funding sources and through your legal representation for your organization. Okay. So we talked a little bit about this, is make sure that there's a statement acknowledging that the survivor has not only read the form, but been informed of alternatives, risks, benefits, and understands the consequences of potentially releasing that information to a third party, right? And usually at the bottom, there is a statement that says, or like a little, where they can like sign, yep, it's on here, right here. So I understand here at the bottom, I understand that I can revoke my permission to release confidential information at any time. This release of information is good until da 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 da. So a question that I usually always get is, well, what if they call and say that they want to revoke their release of information? So what I would do is I would write that on there. I'd have a space, usually there's a space at the bottom that says when release of information was revoked, so on, and then I would write, called on, let's say like April 9th at 10:47 a.m. Survivor said they wanted to revoke their release of information. And then the next time you meet with them, the next time you talk with them, is have that conversation and say, hey, you called and said that you wanted to revoke this information. I want to make sure that this is still something you wanted to do, right? Because we want to verify that that person was the person that called and stuff like that, right? But yeah, so consent, release of information, consenting to releases of information, they cannot be a condition of eligibility. So especially really big, with VAWA, FVPSA and stuff, that you cannot force a survivor, you cannot force, anyone to do something before they can receive services, right? So think about this barrier that we're literally placing in front of the survivor, is that, hey, if you don't give us access, if you don't give a third party access to your information, that we're not going to help you, right? Oh, that is absolutely not trauma informed. That is absolutely scary. That is a huge barrier, right? And think about if this person does continue to engage with resources and engage with your organization, that they are significantly less likely to divulge the actual, abuse and things that have happened to them and are currently happening to them, because they may not feel safe. They may not feel that they can trust you, right? They may not feel that their story or their, experiences are enough, right? Or that they may have to do something else. Oh, so here's a sweet a cat break. So this is Jorge. This was the other day, just him being his perfect little self. I love his blue eyes, and he's great. Okay, so now we're going to talk about the fun part. If all the stuff that we've talked about isn't fun already. So ethical dilemmas in confidentiality, right? Okay, so I want to hear from y'all. So type in that question box. So we receive VAWA FVPSA funding, right? We receive VAWA funding and there is a true emergency. Can we call law enforcement? Can we reach out to folks? Do we have to get a release of information? What do you think? What if there's a true emergency? Can we break confidentiality? What do y'all think? Got a couple people. Okay, So we have a couple of, most folks say yes, 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 yes. Someone definitely says no. One organization says that we have them sign a medical release of information when they come into shelter and when they're receiving services. Yeah. Okay. Interesting. Someone says true emergency. I think you're required to call, but now I'm questioning. Love it. Love that vulnerability, friend. Right? To accomplish life-saving or essential services. But what are you saying is a true emergency? Love it. Love it. Okay. So let's get into this. Someone says my gut tells me no. Have you fallen into my trap, friend? So you do need to get a release of information from a survivor for emergency situations. There are no exceptions under VAWA for emergency situations. People, I get it. Okay, this is very difficult, right? And we need to make sure that we are still getting releases of information and we're having those conversations with survivors and victims before these things happen, right? So think about, say you have a survivor, right? You have a survivor that comes in, say they do have insurance, right? However, if they go to the hospital that's the closest to your organization, that is not covered under their insurance. So they would get significant bills. Maybe the person with abusive behavior works there. Maybe they're a doctor. Maybe they're a nurse. Maybe they're intake staff, right? So think about just in that example that we're having those conversations so that the survivor can choose where they go and what happens with them, right? And think about folks with maybe different religious beliefs or different cultural beliefs that we want to make sure that we're having these conversations and telling them, hey, this is, kind of our standard. This is, what we're maybe even legally held liable for, stuff like this. And so how can we meet your needs while also, adhering to local and federal law, right? Okay. So communicable diseases, this is perfect timing, right? So what do you think? Do you think that if in shelter, in your organization, someone has a communicable disease, say like, measles, do you have to report that to the health department? What do you think? Okay, so no, yes, no, yes, yes, no. So we have literally yes with a question mark. So we literally have, it's mixed, right? Someone said, honestly, I'm not sure. Loving the vulnerability here today. Okay, so let's go into it. So the Utah Communicable Disease Rule. So healthcare providers like doctors, nurses, clinics, stuff like that, are required to report communicable diseases with the local and state health department. If you suspect that there's a client that has a reportable disease, encourage them to see a doctor. Say, I definitely noticing you're having some symptoms, and I would, really suggest that you go see a doctor, right? And so, do it in the most trauma-informed way, right? Is, hey, I'm noticing these things. How can we help get you to a doctor? How can we help with symptoms? What can we? How can we help you get service and care, right? However, if there is an outbreak, in shelter, you are required to report it directly to the health department, okay? So you are required to report it directly to the health department. So for example, if there's a measles outbreak in your organization or shelter, or even right now, things like, potentially COVID, is that there are policies and practices in place, especially for quarantine and other things that, in the health department, helping folks get treatment and also, prophylactics if folks haven't been infected yet, and, things like vaccines and stuff like that. So you will have access to the rule And if you have any questions, you absolutely can reach out to me. You can also reach out to the Utah Department of Health or your local health department, and they are an excellent resource. I do say I am definitely a fan person for Utah Health Department. I think they're wonderful, and they have a lot of really great resources and really an excellent staff that has really supported us and folks throughout the state. So we had a question about this. So, you know, threats of suicide or homicide, right? So in Utah, there is no legal requirement to report if you are a non-licensed person. So if you're not an LCSW, a doctor, so on and so forth, right? However, this should be part of your medical release of information because suicide is incredibly common. And unfortunately, you know, sometimes the way that survivors and victims respond and react to other folks, or when they feel, you know, triggered, you know, when they feel, you know, they feel unsafe, that they may react in a violent way, right? So make sure this is part of your medical release of information. If any of you need help with this, please reach out to me. That is why I'm here. That is why I wake up in the morning, is for folks to reach out to me and for me to help them. Oh, and then I did have a question. Someone said, but do you report the outbreak with names? So call your health department and they will walk you through the reporting requirements. Yep. So remember that your job is to maintain confidentiality any way that you can. However, this is a Utah law, so we're required to do that. However, they will walk you through the reporting process and make sure that you're upholding confidentiality standards. Okay. So then Utah does have a Good Samaritan law. Okay. So part of this is that folks who are providing assistance in a suicide emergency are immune from potential legal consequences, right? Unless you or your organization are, you know, grossly negligent or you caused the suicide emergency. So that's really good to know, is that you do have some, you know, protections behind you. On a state law, is that you won't be held, you know, liable if something does happen. Okay, so Tarasoff warnings. So this is for all you licensed therapists, mental health professionals, LCSWs, so on and so forth, that, you know, every state has a Tarasoff warning. So basically, here's Utah's duty to warn law. So, you know, therapists, they have no duty to warn or take precautions to provide protection from any violent behavior of their client or patient unless when that client or patient communicated to the therapist an actual threat of physical violence against a clearly identified or reasonably identifiable victim. So this is really big in domestic violence cases. So if you have a client that comes in and says, you know, for sake of webinar, definitely not going to say a swear word, but you know, heck, I'm going to kill my partner. I have purchased a gun. I know where they live. I'm going there tomorrow. That you legally have a requirement to warn that victim, so communicate the threat to the victim and to notify law enforcement, right? So that can be really hard. And of course, if anyone is in need of support surrounding that or technical assistance, please reach out to the coalition, and we can support you in that. And also, it is probably a really good idea for you to have conversations with your law enforcement, your local law enforcement agencies, and find out kind of their practices and policies and how to best interact with them and what to do in these situations. So this drug testing and background checks is, I'm going to be honest, is probably one of my my soapbox issues. So let me quickly sanitize my soapbox before I, you know, get on it here. But you cannot, if you receive funding, you know, especially from VAWA and FVPSA, you cannot drug test survivors, victims before they are able to receive services. You cannot do it, okay? You cannot run background checks on survivors before they are able to receive the services either. This is considered a barrier, and what we are trying to do within our jobs, especially in advocacy, is to eliminate barriers, okay? So here's some examples. So drug testing, so here's FVPSA, right? So this is on page 4 of the FAQs. So you're able to find it, and I will, give you access and resources to this as well. But down here, screening tools that cannot be used include criminal background checks, sobriety requirements, or requirements to obtain specific legal remedies or mental health and substance use disorder screenings. So this is very, very explicitly said, especially in FVPSA, right? So we literally cannot do, we can't have these as screening tools. And think about the people that you're screening out are the people that desperately need your services. These are the people that need us the most. And these are the people that we want to screen out. That does not sound very trauma-informed, right? That sounds really difficult. And it's really expensive. And it can take days, it can take weeks for these background checks and for these drug tests to come back. And then that survivor may be in a dangerous situation. That survivor could potentially have an increase in violence and potentially even, unfortunately, domestic violence related homicide during that time. So remember that we're here to serve survivors, we're here to support survivors. We're not here to determine if they are, if they deserve services, okay? And remember, there's a huge difference. A lot of feedback that I get is, folks asking questions like, well, what if someone comes to shelter and they're intoxicated? Well, or, high, right? Well, there's a big difference between someone who is quietly maybe drunk or buzzed versus someone who is high on PCP, or who is a habitual maybe meth user who is high and who is, destroying things. So there's a difference. And remember that you do have policies and practices, and you can, enact those. And when someone is acting in a violent, aggressive, and non-safe way, that you can, take care of that situation, right? Okay, so this is so VAWA. So OVW does not fund activities that jeopardize victim safety, deter or prevent physical or emotional healing for victims. Okay. So procedures or policies that require victims to take certain actions. So examples are orders of protection, counseling, mediation, reporting, criminal remedies, stuff like that. So we cannot require victims to take a certain action to receive services. And that includes drug testing, and that includes background testing. That says that too, also in the second paragraph here, right? So we are not, generally domestic violence service providers are not equipped to provide, chemical dependency counseling that we generally partner with and work with organizations that do. And so that is going to be our biggest asset, is to work with folks that do specialize in that and make sure that we're doing warm handoffs and referrals and supporting survivors. Okay, so we have another cat break. So this picture was taken the other day, and this is to show the size difference of my cats. So the small one is Jorge, and he's probably right now, he ranges from like 6 to 10 pounds, but he's probably about 6 pounds right now. He's in his small season, and Toriko is 3-4 times bigger than Jorge. So yeah, he's a big boy. He's a big boy. Okay, court orders and subpoenas. So let's talk about compelled by statutory mandate, right? So what this means is that we talked about this a little bit earlier, is when a statute or a law requires that you do a certain thing, or that your organization does a certain thing. So child abuse, mandatory reporting, elder abuse, and vulnerable adult mandatory reporting. So we all know that this is something that we have to do. We're compelled by the statute, and that we will not be held liable for breaking confidentiality because we are required legally to do it. So here is, so when this is compelled by either a statute or a court mandate. So we need to make sure that we're doing whatever we can to uphold confidentiality standards. So if we do have to report to DCFS, and we do have to report for suspected child abuse, that we are making reasonable attempts to notify the survivor, that we are doing whatever we can to uphold that confidentiality, okay? Is that when we call them, we're not just saying, okay, here's everything that's ever happened to them, here's their date of birth, here's every piece of everything, right? Is no, we give the information that we're required to by law to DCFS. So think about that, okay? So remember that we're still trying to uphold confidentiality, but we also need to comply with statutes, right? Okay, so there is no prohibition from reporting abuse and neglect. So this is something that we can do because it's defined by statute, right? However, remember that I guess we have a couple folks from other states on there, and I'm unfamiliar with Alabama's mandatory reporting laws, but that would probably be really interesting and important for you to kind of look into that too. If the folks from Alabama, if they want to type in, do you know if you are mandatory reporting, around a mandatory reporter? Ooh, someone said, what is considered best practice when it comes to drug testing after someone is already receiving services in shelter? My question is, why are you drug testing? What is your reasoning behind that? Are you doing it to screen people out? Are you doing it like what is the reasoning behind that? Yeah, so that would be really interesting. Are we doing it to potentially deny further services or to cut someone off from services, or yeah, like what's that? Okay. All right. Okay, so let's see if we covered anything. Okay, so let's talk a little bit more about court mandates, right? So court mandate, that's a judicial, it's always so hard for me to say this. Basically the court's command, they say, all right, you need to do something, you need to provide something, right? But then we have subpoenas, right? So our subpoenas court mandates, okay? So this is a really unclear answer, right? Because there are a lot of things that we can do with a subpoena when we get a subpoena. However, we cannot simply ignore a subpoena. So we never under any circumstances want to ignore a subpoena, right? So most of us have legal representation either on retainer, or we have legal folks on our board or even in our staff. So this would be really something that you would pass along to them because they have a lot of different options that they can do, right? And remember that a subpoena is basically a demand to have a conversation, right? So it's a demand for you to appear, provide testimony, right? And there's a couple of different types of subpoenas. We have this, and again, I took Japanese in undergrad. I did not take Latin, but Deus Tecum. So this is basically requiring you to produce like records or documents, right? So not necessarily a conversation or appearance, but actual documents, right? And so that's really important too, because there are several different types, and you yourself as an advocate or a frontline worker, these really important folks, is that you may not know and understand what is in the subpoena and how to respond. So definitely pass that on to your executive director, pass that on to legal counsel, okay? So really important, is that when someone is delivering a subpoena, is that remember to uphold confidentiality, okay? Is that if someone comes and says, okay, you've been served, right? Don't automatically just start saying and, word vomit all over this person. Absolutely not. Write down notes, the name of the person, how it was served, when it was reserved, if there's a check that's included, but give it to your executive director, or if you have a custodian of records. In all the places that I've worked with and interacted with, I've never known an organization to have a custodian of records, but if you do, I'm here for it, okay? And definitely pass that on to your folks, okay? And then, you know, whoever your legal representation is for your organization, that we're connecting with them, right? So remember that subpoenas, you don't have to immediately respond when that person hands you the document, but they do have to be responded to in a timely manner, right? And that's up to your legal counsel to take care of that, or your executive director to take care of that, okay? So again, remember that we're taking all the steps that we can to provide, to uphold confidentiality and privacy and safety of the survivor, right? So this middle dot point, this best practice is motion to quash or dismiss, or to motion for a protective order, right? So your legal counsel will be able to do this and, you know, file these things. This motion to quash is a really great tool, especially for domestic violence service providers, sexual assault programs, you know, folks that are funded by VAWA, because, you know, folks have to prove why they need this information that is federally protected, right? So, yep. And, you know, of course, make sure that we're having those conversations with survivor. And does the survivor consent to the disclosure of the information? What does the survivor think, right? So here is a little information on what can be shared in VAWA, right? So if we have like non-personally identifying aggregate data, so think about like the quarterly numbers you send out, or your yearly program reviews that, hey, we served, you know, 2,000 survivors, we did 10 support groups or whatever, like that is not personally identifying data. So this is aggregate data that you can share with stakeholders, with funders. You know, funders really like information. They want to know what their money is doing and who it's, you know, helping, stuff like that, right? You know, if it's demographic information that's not personally identifying, right? So, you know, think about some of your demographic information. If you're asking, you know, really specific questions, then that can be problematic. Or if, you know, think about who you're serving, and if you only served, if you're in a rural community and you only served like one trans person, like how could that information potentially be identifying, right? And of course, if there's court-generated information or law enforcement-generated information, that's from a third party, and so that doesn't come from you, and so that's not really something you can control, okay? Okay, so here, this might be our last cat break. I've been, you know, FaceTiming with friends trying to connect, and I found filters on it, and so I took this sweet picture of my cat. Okay, information storage. This is the last, I believe, section before we go over our resources and play our favorite game. So, okay, I want to know this. How many of you know your policies for document retention, for information retention within your organization? How about you raise your hand? How about we do the raise hand feature? Or you can say yes in the question box. Oh, nice, 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 nice. So there's a bunch of folks that, let's see. All right, so we probably have about a fifth of the folks that are on right now who know their retention, their documentation standards. So this is, for everyone else, this is a really good thing for you to delve into. So that's your homework for this week, is to find out what your documentation standards are, right? We want to make sure that, and if you are in a position that you can change policy, make sure that you're reviewing it and making sure that it is consistent, right, throughout the agency. We want to make sure that all of the folks within the agency are reporting and documenting in the same way, right? Think about, you know, if an advocate leaves and the way that they were documenting things is very different than the way other people document things. Even think about maybe policies surrounding subpoenas and providing information to courts. Maybe the information, your policy is to provide a certain type of document, but that document that was prepared by an advocate didn't follow the rules, or there maybe isn't a set rule for documentation, and personal information and information that can be very negatively impact that survivor was included. So think about this, right? And also think about who has access to the information, right? So you want to keep minimal survivor records. You want the least amount of information on the people that come through your organization as possible. Only the stuff that you have to have for audits, funders, stuff like that, right? Legal requirements like that, right? Locked files, having files in maybe a set place, like having a custodian of records, or like an HR person, right? Or your accountant, the person who does your records and your billing, that they be the person who is over all of those records, and they are the person that has the key, right? I've been in several organizations where each advocate has their own locked cabinet that only they have access to, and only they have a key to, and that could be really great and beneficial, because only that person working with those survivors has access to their files, right? So remember that your record should only include things that are literally necessary to deliver services, right? You should not include casual comments, emails, letters, opinions, criticisms, stuff like that, because if you put, hey, survivor B is a super rude buns and never cleans up in the kitchen, yells at people, doesn't ever show up for stuff. If that gets into, a court case, how could that potentially affect that survivor? Of, hey, this person has a history of not, complying or whatever, and that could be really devastating to that person, right? And remember that all the information, everything that you have, could potentially be subpoenaed. So everything that you're keeping in that file cabinet could potentially be presented in a court of law. So don't keep things that you don't need to have in there, right? So of course we want to, I just talk about this. We want to worry about records, because everything that we have in our records, in our offices, in our organizations, could potentially be subpoenaed. It could potentially be presented in a court of law, and we want to make sure that we're upholding confidentiality. Okay. All right. So working with community partners, this is so big, and there's a couple folks on the webinar today that I have personally had conversations with, or we've worked on this together, right? First off, make sure you know not only your policies, but also, when you're reaching out to other organizations, other communities, other, social service, places, folks that could provide you with even support in the clients that you work with, make sure that you are ready to share and explain your confidentiality, your policies and procedures. This is really big, especially for law enforcement. So there's a number of organizations within, the state of Utah that have a one-pager that when law enforcement comes to the door and says, hey, we need to talk to so-and-so, we know they're here, that they, give them the one-pager, or they have that conversation saying, hey, this is where I'm coming from. These are the confidentiality standards that I have to adhere to. And I want to work with you, and I want to, create a partnership with our organizations. And these are, my requirements. What are your requirements? What can we do to work with each other that allows me to adhere to federal confidentiality provisions, right? Also, exchange trainings. If your organization can train a local organization, a law enforcement agency, that's excellent. And can the law enforcement agency train your folks on how to, best work with law enforcement? Absolutely. If you know, you would love for me to come and do trainings, I absolutely will when I can, you know, when social distancing is not a thing. So I am absolutely available to do trainings, to come to meetings, to help bridge these gaps. So if you do need support on this, I am here. I am one text away, I'm one email away, I'm one phone call away, right? So remember, I am a partner in this as well, okay? So, you know, what can you do about these ethical issues surrounding confidentiality? So make sure that we're discussing confidentiality. Make sure that we're talking about this not only with staff, but also with survivors and victims and clients that we're working with. So, you know, a good thing that you can do in staff meeting is each, you know, time you have staff meeting is you bring up an ethical issue surrounding confidentiality or something that has been seen in, you know, in a national case, in a case from another organization, or a hypothetical, and you talk about it, and then you go over, okay, here are the standards. This is what our organization policies are. This is what VAWA dictates, or, you know, VAWA says, and here's some resources and support surrounding that, right? MOUs are great. So memos of understanding are great, especially when you're working with organizations, law enforcement agencies, you know, a lot, is that you have, you know, these shared agreements around confidentiality and the things that you can and will do, and the things that they can and will do. So that could be something to also look into. That could be a really great resource. And I love this bottom one here. You know, clarify that your role is not information sharing. So when we talk about the different types of confidentiality and the different types of laws that are in place, so VAWA is about protecting information, right? So example would be, or so like HIPAA, excuse me, HIPAA is about how do we share information, right? So it's about creating policies and practices on sharing healthcare information. VAWA is creating policies and practices on how to keep information confidential, right? Yeah, so think about like where your funding and your role with confidentiality is in that funding. Yeah, and then so having these conversations with other organizations, and even talking about releases of information and what your releases of information look like, and what versus what theirs look like, right? And really having these conversations and asking questions and answering questions with other folks, other organizations, right? Trying to get us all on the same page, okay? This is what I can do, this is what I can't do, what can you do, and what can't you do, okay? Oh, so here's our last picture. This is a little swathy. It's really quite hilarious that it seems like all the animals that I really enjoy tend to look like raccoons. So sloths, even moose kind of have a little raccoon-like face. So, all right. So now we are going to try it. So we're going to do a little bit of a confidentiality activity, and then we are going to go on to our favorite game. Okay. So here are the instructions. So I'm going to read a scenario. Okay. And I would like for you to type out what you would do in this scenario in the question box. There will be a question that will be asked during it, and then we'll kind of go over it as a group. Okay, here is our scenario. A DHS caseworker calls for a copy of your case file. The caseworker says they had the survivor sign a release of information for the survivor's file and wants you to fax a copy of the file to their secured fax machine ASAP. You know that the file indicates that the participant was asked to leave shelter due to violent behavior. How do you respond to the caseworker? Type in the question box, how do you respond to the caseworker? And remember, we are VAWA funded advocates in this scenario, right? So what do we do? Okay, so some folks are saying ask for a copy of their release of information. Someone said that, let's see, I would have them request specific documents. for what they need. The case file is too vague. Require they send their copy. First, request a copy of the signed. You don't get anything without the actual copy of the release. All right, so, and then someone said, tell them I would need my own release of information from the client. Okay, and someone says, first of all, I can't confirm or deny the presence of a client without seeing an ROI. I love it. Okay, so excellent chiming in here. Let's see what else is on here. Yep, someone says, nope, unless the survivor signs one of our releases of information. Okay, so excellent feedback, y'all. So let's talk about this. Okay, so what we have here is, so we have DHS, right? They have their own release of information, right? So their information says, hey, I can share information to DVSP, so Domestic Violence Service Provider, right? So I can share information that way, okay? So that's what my ROI says. It's really hard to write with a mouse, I've found out. However, we do not have a release of information for us to share, right? So that's not there. So this means that that's great that they have a release of information. What that means is that they can relay information to us, right? But we can't relay information to them. And that includes even confirming or denying, right, that we have ever met this client or know about this client. So the first thing that we can say, is I can't confirm or deny that I've ever, worked with that client, right? However, you're welcome to send over a copy of your release of information and I will look it over. And then you hang up that phone, right? Get out of that meeting. You go contact that survivor and you say, hey survivor, your DHS caseworker reached out to me and said that they wanted a copy of your, case file, and ask, them what they want, what they are trying to do, stuff like that. So get their information and find out what they actually want, and provide information and resources for that scenario. So if the DHS caseworker wants all of the information, but they don't need all the information, make sure that you're communicating that to the survivor. Say, hey, it looks like they are, it sounds like they're trying to get information to verify employment for unemployment benefits or something. So would you like to share this information with them rather than all of your case file, right? Okay, next part of this. What would you do differently if the survivor left shelter for another reason? What would you do differently? Oh, all of you are so great. I love it. You're all nothing, nothing. Same thing. That's great. Good job. You all passed the test. Great job. Okay. So for sake of time, and I'll give you a copy of all these other ones. For sake of time, we are going to go right into our resources, right? And we're going to go into this week's edition of My Cat or Raccoon. Okay. So this one's a tough one, y'all. I'm not going to make this easy for you. I'm not going to make it easy. So what do you think? Do you think this is one of my super sweet deluxe cats? Yes, my cats are deluxe. Or do you think that this is a raccoon? Someone said sloth. Okay. I love it. Okay. All right, are you ready for this? And I hope I don't break no hearts. It looks like we're about a third of the folks say raccoon and about 2/3 say the cat. So it is a cute little raccoon. Oh, it looks like some folks were winners today. Oh, good job. Yeah, it's kind of hard because my cats, both of them, do absolutely look like a raccoon, right? So, um, good job, everyone, good job. We'll see what happens next week. We'll see what happens next week. You did excellent. You did excellent. I definitely look forward to that game every week, and I hope that you do. Y'all are getting good. Y'all are getting good. I can imagine that some of you have been Googling pictures of raccoons and probably Googling pictures of my cat. So good, so good. Okay, so let's talk a little bit about resources. Okay, so again, Utah, we have a number of domestic violence service providers within the state. We have 15 currently, and they provide a number of different services. So not just advocacy, not just support groups. There are many within our state that have traditional housing. Most of our domestic violence service providers are dual providers. So they have a rape crisis team. They have a sexual assault prevention program. They have really great outreach programs. We have a lot of really excellent resources and service providers in Utah, and I am lucky to work with them. Okay, so here's some more great resources, and these will be included in all of the presentations, and I just want to go through them because sometimes it helps to hear them again, right? So Love is Respect. This is excellent, especially when we're working with young folks. All of y'all child advocates out there, all of y'all who are working with teens, this is an excellent resource. They have such good stuff on there, right? Especially for dating relationships, right? Futures Without Violence, love Futures Without Violence. They have excellent webinars going on right now. Definitely check out their website, get on their newsletter, because these organizations are doing wonderful webinars right now and providing really great training and resources. And of course, we have Break the Cycle. So this, again, with dating violence programs, exclusively for young folks, so that 12 to 24 age group, right? Unfortunately, that's a group that sometimes, gets left behind, right? Or we may not have funding for it, or there's funding silos and makes it kind of difficult. And then EDV, excellent resource. So they're a national technical assistance provider. So we work really close with NNEDV. They are a wonderful resource. They're an excellent support, and they have so much cool stuff on their website. Love their website, love it. And then there's the National Domestic Violence Hotline. So this can be accessed 24/7. Also, they will connect you to local resources and information. So if you are like, oh, I don't know where to start, this excellent place to start, right? And we have Strong Hearts Native Helpline. This is absolutely a wonderful resource. So check out their website. They have a lot of really good articles, information that they post online. And they have a helpline that is available every day from 7 a.m. To 10 p.m. Central Standard Time, okay? UCASA, our sibling coalition. So UCASA does a lot of really great work. And check out their website. They have a lot of cool stuff on their website. They do have an app that you can download on your phone with a lot of really good resources, and there is the 24-hour sexual violence crisis line. And then, of course, last but not least, the Utah Domestic Violence Coalition link line, right? So this is available, again, 24/7. And remember that we are not a counseling service. Even though we're located in Salt Lake, we can't meet with clients individually. And also, of course, due to COVID and social distancing, but we are, we unfortunately can't meet with survivors in person. Okay, so you can find us at a number of places. So Facebook, we have Twitter, and then YouTube. So I have uploaded the last couple webinars to YouTube. So if you want to check those out, you can. Definitely pass that along, share that with folks, share that with your staff, and that's where I will upload the webinars, and they will have access to them most readily. And then our website has a lot of resources and lists of webinars. There are some webinars that we that aren't public, but you can get them through additional resources or through us specifically. Yeah, so, okay, here's my contact information. Definitely send me some emails. Definitely, if you call me, this is the office line, and I'm not in the office. I won't be in the office for several, probably for several months due to what's happening right now with COVID and the global pandemic. But if you do call, make sure to leave a voicemail. If you do not leave a voicemail, I will not call you back. So it's not because I don't like you, right? It's because I need to know that it's safe to call you back. So make sure that when you leave a voicemail that you say, hey, definitely call me back, yo, and leave your phone number. And I would love it if you would say your phone number slow and repeat it. So say it twice. That'd be super, super great. All right. And also, let's see. So if someone had a question on, is it possible to view the webinar and take the quiz for CEUs for past trainings? Absolutely. So I will send out a link for those, a PDF. Also, if you do take one and you can't locate the quiz, email me. Definitely email me and I will give you that information and you will be able to do that. So thank you, everyone. You're all super awesome. I loved this webinar. Hopefully you learned a lot. Again, any questions, reach out to me. I am here for you. And I will see you all next week. Thank you. Have an excellent week. Stay safe.